A very warm welcome to all of you, wherever in the world you are, and welcome to our joint session in the series entitled Voices of Contemporary Islamic Thought. My name is Abdullah Saeed. I'm the Sultan of Oman Professor of Arab and Islamic Studies at the University of Melbourne, and also the Director of the National Center for Contemporary Islamic Studies at the university. This webinar is hosted by the Institute of Ismaili Studies in London and the National Center for Contemporary Islamic Studies at the University of Melbourne. The Institute of Ismaili Studies, based in London, was established in 1977 with the objective of promoting scholarship and learning on Muslim cultures, historical as well as contemporary, and encourages a better understanding of their relationship with other societies and faiths. While its broader focus embraces Islam as a whole, it concentrates on Shi'i Islam and its Ismaili persuasion in particular. The National Center for Contemporary Islamic Studies aims to advance knowledge and understanding of the rich traditions and modern complexities of Islam while responding to Australian and regional needs. Let me now say a couple of words about the theme of this webinar. Constitutionalism has become increasingly important for Muslim majority states, especially in the wake of the 20th century's political upheavals. At its heart, constitutionalism is about limiting power, ensuring rulers are accountable, rights are protected, and governance is based on laws rather than personal whims. For many Muslim thinkers and reformers, this has resonated deeply with Islamic principles of justice, which is adl, and consultation, which is shura. In the early 20th century, as colonial powers and colonial rule began to recede, Muslim majority countries were grappling with how to structure new nation states. Some, like Egypt and Iran, experimented early with constitutions that aimed to balance Islamic values with modern legal and political frameworks. But progress was uneven. Military rule, monarchy, and authoritarianism often overpowered democratic impulses. Still, the idea of constitutional governance gained ground. The 1979 Iranian constitution, for example, tried to blend the sovereignty of God with sovereignty of the people, though how that played out in practice is debated. More recently, documents like Tunisia's 2014 constitution reflect a renewed effort to root democracy and rule of law within an Islamic context. Today, for many Muslims, constitutionalism isn't seen as foreign, but as a necessary framework for justice, dignity, and shared governance, ideals that echo Islamic teachings themselves. It is now my pleasure to introduce our speakers to you today. Assistant Professor Hadi Inayat, Dr. Salim Laka, and our moderator, Dr. Muhammad Kishavji. Let me introduce our main speaker first. Hadi Inayat is an assistant professor at the Institute for the Study of Muslim Civilizations at Aga Khan University in London. He specializes in the political sociology of the Middle East with a particular focus on religion, law, political theology, and intellectual history. He is the author or editor of several books, including Law, State, and Society in Modern Iran, Islam and Secularism in Post-Colonial Thought, a cartography of Assadian genealogies, and finally, The Rule of Law in the Islamic Republic of Iran, Power, Institutions, and the Limits of Reform. Dr. Salim Laka is an honorary senior fellow in the School of Social and Political Sciences at the University of Melbourne. He is a specialist in development studies with a particular focus on South Asia. His scholarly publications cover topics such as economic liberalization and the middle class in India, governance and social protection, civil society, and transnational migration. Finally, Dr. Muhammad Kishavji is a South African-born English-trained barrister who is an international specialist on cross-cultural mediation. He is presently a scholar in contemporary Muslim jurisprudence at the Institute of Ismaili Studies. He has published 4 books, including Understanding Sharia, Islamic Law in a Globalized World, which received critical acclaim in a number of journals. He lives in the UK while teaching a summer course on law and society at the Institute of Ismaili Studies. I will now pass the baton to Dr. Kishavji, who will moderate our session today. Thank you.
Thank you very much, Professor Saeed, for that very, very generous introduction. Hello, Hadi, Professor Inayat. Hadi, if I may. I think in this particular program, if it was okay with you, I will refer to you as Hadi, and I will refer to our colleague, Dr. Laka, as Salim, and please feel free to refer to me as Mohammed so that we can move on to a more spontaneous discussion rather than a formal one. And thank you for being on this program, both of you. Perhaps, Hadi, if I could ask you for our audience, whether you can, in very simple language, explain what is a constitution and why a country needs to have one. What are the main functions of a constitution?
Sure. Well, we all need certain things: a voice in political decisions, food, shelter, security, recognition, and respect as individuals and communities. To help meet these needs, people create governments and delegate powers to them to exercise for the common good. The problem is, however, that while governments need power to comport these functions, history tells us over and over again that power without limits can lead to corruption, dictatorship, and oppression. Free and fair elections are one vital way of limiting the power of rulers, but we also need some basic rules to control how that power is used so that those who win elections still have to respect your rights and promote your interests rather than using power for their own benefit. Just like in cricket or football, there have to be rules and a referee, so in a democracy, there have to be rules which apply equally to both rulers and ruled. These rules are provided in a constitution, which is a law, but not just an ordinary law. A constitution is a supreme law that establishes, organizes, and empowers the government and determines how other laws are made and implemented. It's also more difficult to change than ordinary laws. Football wouldn't be fair if the winning team could change the rules, and democracy wouldn't be fair if those in power can just change the constitution on a whim. The constitution harnesses the energy and power of the state, ensuring that people control the state. This is why when people are trying to establish a new and fairer society, one of the first things they do is to write a constitution. For example, in India in 1949, in South Africa in 1996, and in Tunisia in 2013. So constitutions tend to be rewritten after a major political crisis, such as a war or a revolution or a struggle for independence. Conversely, when a democratic government is illegally overthrown, one of the first things that the coup leaders do is to set their sights on destroying, suspending, or amending the constitution so that there are no inconvenient limits on their power. This was the case, for example, in Chile after the coup by General Pinochet in 1980, in Turkey after the military coup in 1980 again, and after the coup in Egypt in 2014. So a constitution both organizes and restrains political power. This is one of the paradoxes of constitutionalism, which we'll come back to. How does it do this? Well, there are several ways. One way is to divide power between political institutions, for example, sharing functions between a president and a prime minister, or between two houses of parliament, or by dividing power between local and central government. A constitution defines the power of these institutions and regulates the relationship between them. It also ensures that power is rotated. One year we might vote for one candidate or party, and a few years later we might vote them out when their constitutionally defined term is finished. This means that no one person, party, or institution can maintain power for too long. Constitutions also constrain power by specifying what rights people have and what governments must and must not do. For example, a set of constitutional rights may prohibit torture, and they may say that you can't be imprisoned without due process and that your freedom of expression can't be infringed. Some constitutions also provide for social and economic rights, such as welfare, education, and health. But constitutions don't only protect majorities. There may be special provisions for minorities and marginalized groups for their security, their participation in government, and their identity and culture. Most constitutions have a nation-building function to them, and they often, function very importantly as kind of symbolic entities. They seek to embody the national unity of the people and to reflect and declare the identity of the nation and its people. The Constitution announces to its citizens, to the government itself, and to the outside world what the nation is, what it stands for, where it comes from, and what its vision of the future is or should be. So a good constitution is just one step along the road to a peaceful, prosperous, and democratic society, but it's a vital one. By setting down the rules by which the state should be governed, a good constitution helps ensure that the democratic aspirations of the people become a reality.
Thank you, Hadi, for that very beautiful, basic background. Now, for many in the world, the concept of constitutionalism is associated today with the Western world. For the more discerning, one can go back to the ancient Greeks and the Romans. One gets the feeling that this notion does not exist in the Muslim juridical consciousness. And yet we often hear of the Compact of Medina. Can you throw some light on that document and tell us how Muslims first became familiar with the concept of modern constitutionalism and what endeavors took place in the 19th century in this regard?
So one of the most powerful resources in the Islamic tradition for imagining an authentically Islamic constitution is the so-called Charter of Medina, or sometimes is referred to as the Constitution of Medina, written and promulgated by the Prophet Muhammad, peace be upon him, after his migration from Mecca to Medina in 622 of the Common Era. The Charter formed an alliance among several local pagan tribes and Muslim immigrants to Mecca. The Ummah, the community defined in the Charter, had a distinctly religious outlook which aspired to transcend existing pagan tribal identities and create a new community where faith served as a foundational binding concept. Whilst the Charter didn't constrain or regulate power in the manner of modern constitutions, it did address such issues such as taxation and some aspects of day-to-day governance. Moreover, it specified the rights and duties of citizens as well as the relationship between Muslim and non-Muslim communities, most notably Jews, and enshrined equality before the law for all communities, though this was later changed when the non-Muslim communities were given a dhimmi status as protected but inferior communities, or millets as they became known in the Ottoman Empire. The Charter of Medina has been characterized in very different ways, with some scholars referring to it as the earliest written constitution in the world, which contained ideas which are in many regards similar to the core aspirations of modern constitutionalism. Other commentators have opted for a more modest view, stressing the document's character as a mere municipal charter or treaty, whose elevation to constitutional status may have more to do with 20th century politics in the Muslim world than anything inherent in the text. Some Islamist intellectuals and parties in the 1990s began to promote the Charter of Medina, for example, Islamists in Turkey, the Refah Party in Turkey, as a model for an Islamic state. However, even today, discussions on the relevance of the Charter for Islamic constitutionalism is largely confined to the academic or discursive level, and its influence on the practice of constitution making in the Muslim majority countries has remained negligible. The ideal of government constrained by a higher law, a central aspect of constitutionalism, was also articulated in medieval Muslim thought. For example, in the 14th century, Ibn Khaldun divided all political systems into three types. The first system he describes as a lawless system, one which approximates with the state of nature, in which the most powerful dominate and tyrannize the rest. The second system he describes as dynastic, but tyrannical as well, because it's based on laws issued by a king or a prince. However, due to their human origin, these laws are arbitrary, and so people obey them out of compulsion or necessity. The third and most superior system, according to Ibn Khaldun, is the caliphate, which is based on the Sharia. As a higher law, which the government cannot arbitrarily alter, Sharia fulfills the criteria of justice and legitimacy and binds the governed and the governor alike in a system of just rule. Some scholars have argued that the picture of Islamic constitutionalism envisioned by Ibn Khaldun mirrored the political and institutional reality in the pre-modern Muslim world. Noah Feldman, for example, argues that the classical Islamic constitution was informed and legitimated by law and shows how executive power was balanced by the ulama, who interpreted and administered the Sharia. Others have challenged this picture and have shown that whilst there was a separation of powers, with the ulama controlling the realm of the Sharia and rulers the realm of siyasa, which broadly means secular administrative law, the former were firmly subordinated by the latter, i.e. the ulama were controlled very much by the sultan much of the time and failed to act as a kind of independent check on the power of the sultan. Of course, ulama-state relations varied a great deal across time and space. Ahmed Kuru, for example, has argued that in the earlier Islamic centuries, between the 8th and the 11th centuries, the ulama had more independence from rulers and were often supported by independent merchants, and indeed were often merchants themselves. This pattern changed dramatically with the establishment of the Nizamiya madrasa system established by the Seljuk statesman Nizam al-Mulk in the 11th century. Under this system, state authorities co-opted the ulama and their educational and legal institutions in order to garner legitimacy. And in exchange, the rulers promoted Sunni orthodoxy and patronized the ulama. According to Kuru, this system of ulama-state cooperation, established under the Seljuks, became the template for the later Ottoman, Safavid, and Mughal empires, in which the ulama were mainly employees of the state and generally supported rulers even if they had become despotic. I should note actually that one important exception to that is the Qajar Empire in Iran in the 19th century, in which there was a kind of separation between religion and state, in which the ulama, who eventually became organized in a hierarchy with the ayatollahs at the top, in which the believers paying taxes, religious taxes to the ayatollahs, maintained a great deal of independence from the Qajar Shahs, and that's a very, very different pattern of ulama-state relations compared to the Sunni empires. Whatever the truth of these debates, constitutionalism in its modern form was first experienced by Muslims as an essentially European concept in the context of colonialism. 19th century constitutionalist movements were driven by elites that pursued legally constituted government as a vehicle of political and economic modernization and for strengthening the state in the face of increasing imperial incursions into the Muslim world. This period of external colonial pressure and internal constitutional reform is often dated to 1839, when the Ottoman authorities issued the Gulhane Decree. This decree abolished the old millet system and gave the empire's non-Muslims legal rights equal to that of the Muslims, and Ottoman statesmen expected, in vain it turned out, that this concession would reinforce the loyalty of non-Muslim communities to the state. And these non-Muslim communities were now beginning to organize themselves into nationalist movements, which eventually broke off and became independent nation states like Greece and Serbia and countries like that. So, but the first comprehensive written constitution in the Muslim world was promulgated in Tunisia in 1861, which established a framework for governance which guaranteed certain civil and religious liberties. A notable feature of this constitution is that it sought to bind reigning monarchs to the rule of law without any explicit mention of Islam or the Sharia, except for the single mention of a Sharia council, the powers of which were never specified in the text itself. There is no mention of an official religion or any obligations towards Islam itself in that text. The Tunisian Constitution of 1861 was followed by the 1876 and 1906 constitutions in the Ottoman Empire and the 1907 constitution in Qajar, Iran. These early constitutional experiments in Tunisia, Turkey, and Iran are part of the reason why these three countries have developed quite robust democratic political cultures and movements, even though they've been under authoritarian rule for most of their modern history.
Thank you, Hadi. I mean, that's a very comprehensive and comprehensible background you've given us. Obviously, constitutionalism is under great challenge, not only in some of the countries of the so-called South, but we're beginning to see major challenges even in the Western world. Over the last 2 decades of this century, developments have taken place in the area of constitutionalism in some Muslim countries. Yet the promise that the Arab Spring held out seems substantially unfulfilled. We saw this in places like Tunisia and Egypt. I mean, we've seen this over the last 20, 25 years. Can you elaborate on this phenomenon and throw some light on what you feel might have gone wrong and what the future holds for some of those countries from a constitutional point of view? So we saw developments also in the last 2 decades, and we began to see new thinking in the field of constitutional reform, if you may, or constitutional rethinking. But the promise didn't seem to have materialized for some reason. Might you be able to throw some light on that, Hadi?
Sure, I'll try. So Tunisia and Egypt have now both reverted to authoritarianism under the rules of Presidents Kais Saied and Abdel Fattah Sisi, respectively. But for nearly a decade, Tunisia managed to institute a fragile constitutional democracy, whilst Egypt's democratic interlude only lasted for a year. The Tunisian experiment, now apparently over, may, however, still hold out lessons for the future, and a brief comparison of the two cases might be useful. There are many structural reasons why Tunisia progressed politically while Egypt quickly reverted to authoritarianism. The most prominent was the exponentially greater power of the Egyptian military compared to Tunisia and its far larger and poorer population. Other analysts point to Ennahda, the main Islamist party in Tunisia, Ennahda's capacity and willingness to compromise compared to the Egyptian Muslim Brotherhood, while others cite factors such as the absence of oil or a hereditary system of government. There is, however, evidence that the civil society participation in the constitution building in Tunisia was also an important factor helping to facilitate its relatively successful, though in the end temporary, transition. A key actor here was the General Union of Tunisian Workers, or the UGTT, as it's known. Perhaps the only organization whose power and legitimacy rivaled those of the Islamists in Tunisia. The union played a major role in the anti-colonial struggle against the French and fought to maintain its autonomy under the authoritarian regimes of Habib Bourguiba and Ben Ali, unlike in Egypt, where unions were mostly controlled by the state. Thus, the UGTT had the networks and the negotiating and mediating experience acquired through collective bargaining to facilitate a national dialogue, which managed to reconcile the Islamist and secular parties in a way which didn't happen in Egypt, where there was much more polarization. For a while, Tunisia's political settlement looked secure, and Tunisians were widely praised for proving that ideological differences need not lead to conflict or stalemate. The pragmatic and result-based approach that the Tunisian negotiators adopted was seen as a positive example of successful constitution making and conflict resolution, not just for the Muslim world, but for much of the rest of the world as well. But the new constitutional order proved to be fragile and never managed to establish hegemony. Slowly, the ancien regime began to re-establish itself with the Nida Tunis and Nahda coalition government, which embraced the failed neoliberal economic model, which brought Tunisia to revolution in the first place in 2011. An increasingly deteriorating economic situation, combined with police brutality and state authoritarianism, increased popular discontent and led to widespread cynicism about the post-revolutionary state in Tunisia. This eventually led to a reversion to full-scale authoritarianism under the presidency of Kais Saied, who in 2021 announced a state of emergency, dissolved parliament, and granted himself full powers. The following year, he instituted a constitutional reform that has turned Tunisia into a hyper-presidential republic, bringing to an end Tunisia's democratic interlude, for now at least. I think one lesson to be learned from that experience is that if economic inequality is not tackled and grows to too far an extreme, the risk of authoritarian backsliding is magnified, as we've seen in many countries around the world, most notably the US right now.
Hadi, there's one interesting point you touched on. As a mediation specialist, it appeals very much to me, is that notion that there was a sort of a moratorium where you didn't run to a court of law to determine an issue. And I think the union played that important role, where civil society engagement was the process by which consensus was engendered, rather than a top-down decision from a constitutional court. To me, that says a lot about while a court of law can help in the process, sometimes it could become a delaying factor. And I thought that was quite an interesting factor in achieving a sense of consensual politics. Maybe something to learn from. I do not know how valuable that was, but it does show a lot of potential of a non-adversarial approach to achieving a sense of consensus and of a collaborative process. Might you just want to give a short comment on that if you wish to, but I just thought I would make that by way of comment from myself.
Thank you. Yeah, I completely agree. But yeah, briefly, I think the most successful versions of constitutionalism are ones in which courts play less of a role, actually, and judges are less powerful. And, you know, constitutional courts, which are too powerful, tend to create conflict and produce winner-takes-all type decisions. And they need to, and even though I think they're important, of course, I think they need to be complemented by political and dialogical forms of constitutionalism, which involve channels of communication with the wider society and with wider civil society groups.
Hadi, thank you for that background. I'm just going to ask you one more question before we give the podium or the stage to Salim. You know, in the Muslim world today, and for some time now, we see women participating in processes of civil society, including in the government on some very critical issues. How are provisions made in the constitutions in Muslim countries ensuring women's role in government and civil society governing institutions? I mean, when you look at the last 50 years, when I think of places like Algeria, when I think of places like South Africa, for example, when I think of other countries in the developing world, including South Asia, India, Pakistan, Bangladesh, women have played an important role. But how are these provided for in constitutional instruments? Are they specific, or are they implied, or are they things taken for granted that they don't even need to be mentioned? And yet not much is known about that.
Well, I think, you know, it's a very complex landscape, and it varies a lot, of course, right across the Muslim world. But there are several provisions in various constitutions in Muslim majority countries which provide for gender equality. Article 25 of the Pakistani constitution, for example, prohibits discrimination of any kind towards women. Article 21 of the Tunisian constitution also provides for gender equality, and that was one of the big bones of contention in the Constituent Assembly in Tunisia between Ennahda and the secular bloc. And Ennahda wanted to phrase that particular article as men and women are complementary rather than equal. But in the end, they compromised and agreed to a gender equality clause. So that was a very important moment, actually. Women's participation in the institutions of central and local government are also enshrined in some constitutions. The Pakistani constitution, to take that example again, specifies that women should have a certain number of seats in the parliament and at the local government level. This was also the case with the now defunct Afghani constitution promulgated in 2005, which reserved a minimum of 27% of seats for women in the parliament, a rate much higher than many countries around the world. Many Muslim majority countries are also signatories to CEDAW, which is the Convention on the Elimination of All Forms of Discrimination Against Women, a UN treaty often referred to as an international bill of rights for women, outlining women's human rights to equality and non-discrimination. But whilst these constitutional clauses and treaties are important, they're often flouted in practice. And there is a tension in the constitution of states that have enshrined gender equality, but at the same time contain Sharia guarantee clauses that have often been interpreted in ways detrimental to women's rights. Moreover, the Muslim majority countries that have signed up to CEDAW have often inserted exceptions and reservations into the treaty, which have diluted their commitment to gender equality. Of course, women have risen right to the top in some Muslim majority countries, including in some of the most conservative ones. Benazir Bhutto in Pakistan and Sheikh Hasina in Bangladesh, for example. But I think these have been more down to individual charisma, political nous, and dynastic party politics than with constitutional provisions. Indeed, I would say that gender equality is one of the areas in which the gap between constitutional provisions and political reality is one of the widest, because formal equality in the public sphere is often undermined by acute gender inequality and patriarchy in the private sphere, especially in the realm of the family. Part of the problem here is that even when constitutions provide for gender equality, other spheres of the law, such as the penal law or family law, tend to enshrine patriarchy and gender inequality in favor of men. For example, a man's testimony is worth twice that of a woman's, a man is allowed to discipline his wife, and men's inheritance is twice that of women. So it's a complicated picture.
Yeah, thank you so much, because in an earlier book that we wrote, Understanding Sharia, Islamic Law in a Globalized World, we were able to show that civil society groups in Gambia, for example, dealing with female genital mutilation, in Malaysia, dealing with women's rights in the family context, with the Sisters in Islam, for example, in other parts of the Muslim world, women have played a very critical role in civil society conscientization. But obviously, there's always the tension between the constitution itself, its commitment to certain principles, then the international treaty obligations that the country signs up to, and the reality in the marketplace, as they say. But I think that you've given us an excellent background on that one, and obviously it's a longer discussion that could take a few hours. I thought I will now pass the baton to Salim, who comes from a development background and also an anthropological background, an historical background. So Salim, over to you with what you feel are the questions that have been engaging your mind and some that you've been coming across with people you've been interacting with.
Thank you, Mohammed, and thank you very much, Hadi, for an excellent exposition. I really appreciate the clarity with which you have explained what are very complex issues and processes. However, there are several questions that come to my mind. And to begin with, in talking of constitutionalism, there is the question of sovereignty. there is the authority to govern. In Britain, for example, the authority of governing is vested in the parliament, which represents the people. Might you be able to shed some light on this particular issue with reference to Muslim countries?
Of course, thank you. It's an excellent question. The picture varies a great deal in Muslim majority countries. Some are monarchies in which sovereignty is formally held in the hands of the monarch. Others are republics like Egypt, which have almost invariably been presidential or hyper-presidential systems in which sovereignty is formally or informally in the hands of the president and his allies, often from the military. Most of these constitutions, however, do pay lip service to the notion that sovereignty is also somehow in the hands of the people, even if this isn't realized in practice. Perhaps the most distinctive feature of Muslim understandings of sovereignty is the notion of the sovereignty of God, Hakimiyat Allah. This concept has had a prominent place in Islamist discourses. Key figures like Abu Ala Maududi of Pakistan and Sayyid Qutb of Egypt have argued that anything less than exclusive submission to God's law and all that it necessitates in religious and political terms is idolatry. Yet the idea of the sovereignty of God has been invoked by many more people than the Islamists, and it's meant quite different things to different people in different quarters. The Pakistani intellectual Fazlur Rahman, for example, rejected Maududi's understanding of the sovereignty of God, writing that, quote, any student of political history knows that the term sovereign as a political term is of relatively recent coinage and denotes a definite and defined factor in a society to which rightfully belongs coercive force in order to obtain obedience to its will. It is absolutely obvious that God is not a sovereign in this sense, and that only people can be and are sovereign, since only to them belongs ultimate coercive force, unquote. So whilst Fazlur Rahman, of course, believed that God is in a sense, he qualified this by saying something along the lines that God is a sovereign in a metaphysical sense. God is clearly not a sovereign, in this world. It tends to be people and governments. An interesting case of how the tension between the sovereignty of God and popular sovereignty has played out in practice is the Islamic Republic of Iran, which has a dual notion of sovereignty in its constitution, which recognizes the sovereignty of God through the rule of the supreme leader, or the faqih, and the sovereignty of people enshrined in its democratically elected institutions. This has created tensions between the constitution's unelected Islamic components, the supreme leader, the guardian council, and the Maslahat Council, and its democratically elected institutions, the president, the parliament, and local municipalities. The former, of course, have been much more powerful than the latter, and this trend has been exacerbated in the last decade or so, with the Islamic Revolutionary Guard Corps increasingly throwing their weight behind the supreme leader and the more conservative and hardline elements in Iran. This trend, however, was somewhat bucked recently in Iran by the surprise election of the reformist president Masoud Pezeshkian last year, showing that despite the increasing authoritarianism in Iran, elections still matter. Finally, the widespread application of emergency laws in some Muslim majority countries has led to a de facto permanent state of exception in which the rule of law is suspended, allowing the sovereign authority, often the executive, to act outside the established constitutional framework, violating fundamental rights and freedoms in the name of public good or crisis management. Examples of this, as we have seen, are Tunisia under Kais Saied and Egypt under Abdel Fattah Sisi. But again, this trend is unfolding well beyond the Muslim world, especially after the COVID-19 pandemic, in which emergency laws have been used to expand political power, even when the emergency is clearly over and the public are no longer in danger. Hungary under Viktor Orban's presidency is a striking example of this permanent rule of exception, if you like.
Okay, thank you, Hadi, on that. My next question relates to the possibility of review of constitutions in Muslim countries. Now, the situation at the moment is very different, one might say, compared to 50 or more years ago. And if we're talking about review of constitutions, The question arises, what kind of knowledge, sensitivity, and skill sets would constitutional reformers require that are in keeping with contemporary challenges that are posed by social and political conditions which prevail now?
Thank you very much. Yeah, very good question again. Indeed, there have been many changes over the last 50 years when most Muslim majority, compared to 50 years ago, when most Muslim majority states adopted secular Western style constitutions. From the 1970s onwards, with the rise of an increasing popularity of Islamist movements, the constitutional landscape has been transformed. A popular move is to Islamicize both the constitution and the overall legal order by including a Sharia clause that confers preferential status upon Islamic law. Clauses of this kind spread at a growing rate beginning in the 1990s and now appear in the constitutions of roughly half of all Muslim majority countries. Sharia clauses come in two main varieties: repugnancy clauses and source of law clauses. Repugnancy clauses provide that laws contrary to or repugnant to Islamic law are void. Such clauses were pioneered by the Iranian Constitution of 1906 and 7 and have since appeared in over a dozen other constitutions, most notably Pakistan. Source of law clauses provide that Sharia shall be an important source of state law, or perhaps even the primary or exclusive source of state law, depending on their wording. Clauses of this type made their debut in the Syrian Constitution of 1950 and are more common than repugnancy clauses. In some countries such as Egypt and the United Arab Emirates, where courts have construed such clauses as directing or authorizing them to review legislation for its compatibility with Islamic law. So today we can characterize Muslim majority states into broadly four categories in terms of their constitutions. Firstly, secular constitutions with no official role for Sharia, and examples here are Turkey and the legal systems of post-socialist Central Asian republics. Though we should note that the Sharia, especially in rural areas, for a long time and even up to the present day, still has an important role. Secondly, constitutions in which secular law often prevails, but in which Islamic law also plays a part as a result of a Sharia guarantee clause. This is normally confined to family law and the law of waqf, that means a kind of charitable trust. This is by far the most common type in the Muslim world and includes countries such as Egypt, where recognition of the Sharia as a source of constitutional law did not result in the Islamization of the whole system and was undertaken mostly for the strategic purposes of weakening or undermining the demands of Islamist opposition movements. Thirdly, constitutions or legal systems such as Saudi Arabia's or Afghanistan's under the Taliban, which are dominated by the Sharia, where legislation can only take place in areas which Sharia is silent or equivocal. And fourthly, constitutions that have re-Islamicized previously secular legal systems, usually as a result of an Islamist takeover, such as in Iran, Sudan, Afghanistan, and various states of the Nigerian Federation. This re-Islamization has been implemented by introducing Islamic law codes in many fields previously ruled by secular law, notably in the area of criminal law. What kind of training should constitutional reformers have in this kind of context, complicated landscape? Well, I would say that they should have a deep knowledge of both Sharia and secular human rights law, but also a knowledge of sociology, so they understand the complexity and power dynamics of the societies in which they work. More specifically, they should understand the heterogeneity of the societies they work in and the intersectionality of gender, race, religion, class, and sexuality, and ideally themselves be drawn from a variety of backgrounds in terms of their gender, race, religion, and class. They should also be reflective, ideally, this is in my opinion, about the limits of the law and the relationship between law and democracy. Ideally, constitutions should be reformed or written by constituent assemblies composed of democratically elected representatives rather than by unelected politicians, jurists, or religious scholars.
Thank you, Hadi. I think that's such an
Thank you.
interesting question. Salim, if I may just make one little comment before you ask your next question, that this is an issue that's been engaging my mind for recent times. I come across young students who come to me and says, "You're a lawyer. What type of law should we go into that would be of value in our career, but also in the role that we can play towards this area of development?" And ironically enough, I started my legal career, or I continued my legal career in 3 continents, and constitutional law was not my forte. I was just thinking this morning as I was coming to this session that if I had to become a lawyer again, I think I would study constitutional law quite seriously. But that's 50 years after the event. So, Salim, I think that's a very interesting question for young students today, boys
Yes.
and girls, young men and young women, to reflect on. That when you have these intersections between citizenship, identity, belonging, social equality, social justice, pluralistic participation, what type of skill sets does one need to bring to bear on the whole constitution reform movement a much greater perspective than just a very rigid, robotic, rules-based idea. And I think that constitutionalism has such richness in its thought process. I always recall L.B. Sachs of South Africa and his work in the whole constitutional building process in South Africa, working with people like Oliver Tambo of the African National Congress, people like the first post-apartheid Chief Justice Ismail Mohammed. These were brilliant thinkers who were able to draw on a large panoply of resources. And to think that how many of our constitutional reformers have even read Ibn Khaldun and what he said in the 14th century, which, as Malis Riven reminded me the other day, was so valuable for his understanding of the whole political process in the Muslim world in modern times. So I just thought I'll throw in that comment. And back to you, Salim. Thank you very much for that very
No,
thoughtful question.
thank you, Mohammed, for that, because you raised the issue of social justice. And my next question flows from that particular point, in that a fundamental critique of constitutionalism posits the upholding of the status quo. There is marginalization of certain minorities and the consolidation of the position of the rich and privileged. How do you feel the constitution of Muslim countries can be sensitive to the need to respond to change? And are there promising trends in the Muslim world that you can point to in that regard?
Thank you. Yes, indeed. This is a defect in constitutionalism, which has become more amplified in recent times globally. Constitutions are emphatically not innocent devices and never have been. And from the outset, written constitutions have been as much to do with enabling varieties of power as they have been with restricting power. Some were written to limit what a monarch could do, but some were written to justify royal or imperial omnipotence. And paradoxically, some constitutions were designed to do both. As the 19th century drew on, European colonizers composed constitutions to make sure that indigenous peoples and slaves, and women often, were locked out of citizenship and denied property rights, for example. More specifically, constitutions often contain counter-majoritarian clauses and institutions ostensibly to protect the rights of minorities and establish the rule of law, but which can also undermine democracy, especially when unelected judges strike down legislation passed by democratically elected officials. These problems are particularly visible right now in the case of the US Constitution, which from its origins contained elitist and anti-democratic elements, which due to demographic changes and political realignments in the US have come to the fore in recent years, especially the distorting effects of the Electoral College on election results, which means that a candidate that wins a minority of the vote can become president. That's happened twice in recent years. and the appointment system of Supreme Court judges, who often serve for 3 decades or more in an extremely powerful position, even though they're unelected. Many have called for constitutional reform in the US, but this points to another flaw in the US Constitution, which is the difficulty of changing it, requiring a 2/3 majority in both of the houses and three-quarters of the states to ratify any amendment. There is, of course, a crisis of constitutional democracy and liberalism worldwide. What can people struggling for democratic change learn from this? That any credible constitutional reform in a more democratic direction will demand the toleration of a certain degree of ambiguity and paradox when formulating and adjudicating constitutional principles, especially those that underpin religion-state relations in Muslim-majority countries. Such issues will need to be resolved primarily by democratic deliberation, a dialogue with the ulama, and civil society activism. But the courts will need to play a vital role too, especially in protecting the rights of individuals and minorities. This might best be realized through a method of legal interpretation that Cass Sunstein, an American political scientist, refers to as judicial minimalism. This is a method which honors a legal polity's ideals, but avoids judicial overreach. Such an approach will be attentive to the existence of disagreement in heterogeneous societies and avoid unduly legalizing issues which need to be resolved through democratic processes. Minimalist judges rely on narrow rulings and shallow justifications, leaving as much open to the future as they can, and thus allowing the population, through democratic deliberation, to gradually give meaning to foundational constitutional principles. Indeed, I think a lesson to be learned from the problems caused by the overbearing power of the Supreme Court in the US is that constitutionalism should not only be left to the courts, but should ideally be a collaborative enterprise involving all 3 branches of government, the judiciary, the executive, and the legislature. Another basic lesson from the current global conjuncture, which has seen the rise of far-right populism and neo-fascism around the world, is that we need to fight to establish and then to sustain democracy. For a long time, we've been complacent, thinking that once constitutional democracy has been established, then it will be self-sustaining and it would last forever. As we're seeing around the world today, this isn't the case, and that these systems are fragile and extremely prone to right-wing populist and elitist co-option. And finally, the broader lesson is that constitutional democracy can't be sustained in conditions of extreme economic inequality.
Thank you, Inayat. I find your comparative references very illuminating, and your concluding statement about democracy, don't take it for granted. I think that is an important lesson. Thank you very much. Mohammed, back to you.
Thank you so much, Salim, for those very thought-provoking questions, which I think younger people who are studying sociology, development studies, constitutional law, economics, would all be very interested in today. Hadi, what have we taken from your presentation today? First of all, it's very interesting to note that the notion of constitutionalism is not something new to the Muslim world. I mean, in the 19th century, when these issues were so prevalent, there was discourse in, as you say, in Tunisia in 1861. That's very, very early on. And that there was discourse in Turkey, as you said. There was a lot of thinking on this whole branch in Iran. And also, what we've been more used to, I think we come from a similar type of vintage, are the developments of the last 50 years, because we saw the decolonization process from 1947, 48, 49, in what happened in India and Pakistan, what happened slightly earlier in, I think, places like Syria and maybe Indonesia at that time. And then we saw East Africa, Kenya, Uganda, Tanzania, where I grew up. Salim, both of us grew up in that area. I thought that the post-colonial constitutions were important for dealing with the changes that were engendered at the time of end of empire. But we've seen now, 50 years later, that new demographic realities have come into place, earlier demographic realities that were not fully taken into account are beginning to acquire greater significance now. We have issues of greater conscientization about issues like Black Lives Matter, questions of gender rights, women's rights, children's rights, international treaty obligations. These have thrown new realities in place. And one tends to often feel that constitutionalism is a problem in only one part of the world. But if we really look at the reality today, one of the oldest democracies in the world, which is Britain, does not even have a written constitution. And yet, new democracies or new countries have written constitutions, but the notion of dealing with realities are complex, so problematic. So you've given us an idea that this is not a simple linear process, simplistically to be understood, but it is a much more granular subject for us to come to grips with, taking into consideration the different type of realities one lives under, whether it's the incorporation of a religious law in the whole notion of the social compact, whether it's a condition of understanding different demographic realities, but it's a much complex issue that calls for deeper reflection. And I think, Hadi, in a very short period, you've been able to give us a very clear exposition about the notion of constitutionalism, the different types of constitution that exists in the Muslim world, and also how this is work in progress. It's not a dried and dusted issue. There's still a great deal of work to be done in this area, not only in the developing South, the so-called developing South, or in the Muslim world, but indeed in most of the countries of the world today. So I wanted to take this occasion, Hadi, of thanking you most warmly for giving us this presentation. I would like to also extend my warmest gratitude to both Akhil and Rehana from the Institute of Ismaili Studies here, who have really gone out of their way to help us put this program together, to Professor Sayeed for his very generous introduction and collaboration and assistance to us, and all those, to you, Salim, for your perspectives that you brought in, which I think would be of tremendous interest to our students, and to say thank you to all of you for a wonderful session. Thank you so much.